Marcia Condoy Truyenque has a master's degree in animal law from Lewis and Clark College in Portland, where she has also been serving as a research assistant for the Center for Animal Law. And this is a world-renowned program. It's really the first of its kind in terms of a legal program focused specifically on animals. And thus it brings people in from all over the world to do research and study at Lewis and Clark in Portland. And Marcia is from Peru, where in addition to her work in academia, she is also a practicing attorney who has significant experience working in labor law and constitutional law, as well as investigative experience in international law, international human rights law, as well as animal law. And currently she directs the animal law area of Preston Plus Law Firm, which is incidentally the first law firm in Peru with a specialized area in animal law. She is also currently a junior fellow at the Global Research Network Animals and Biodiversity think tank. And she has been a research fellow at the NCOA International Human Rights Organization, where she was also the director of the Center for Research and Defense of Vulnerable Populations in 2020. In 2018, she founded Ailu Vegano to promote veganism in Peru. And she has been a correspondent in Peru for AFADA, and that is the Argentinian Association of Officials and Lawyers for Animal Rights, and that she served in that position until February of 2022. So in terms of her academic research, it's centered on conceptions of dignity in animals, the relationship between human rights and animal rights, as well as labor rights for animals. So thanks so much for being with us today, Marcia.
Javier, thank you so much. Hello, everyone.
Well, thanks so much for joining us for this discussion. To get started, I just wanted to ask if you could give us just a brief discussion and a brief overview of the field of animal law and perhaps some of your experience in the field and what brought you to the field of animal law.
Yes, of course. Thank you. Thank you so much for inviting me to this class. And yes, as you mentioned, I am a lawyer, but no a common lawyer, because I am not dedicated to the traditional fields of law. The traditional fields of law are civil law, property law, industry law, human rights, or constitutional law. In my case, I am dedicated to animal law. That is a new field. And in the same way that civil law or criminal law, etc., the traditional fields, animal law is dedicated to study the legislation, create legislation, and also study the constitution, but only refer to animals, how the legislation affects animals, how legislation can benefit animals, how the constitution could be a good opportunity for protecting animals, or can be an obstacle for protecting animals. So basically, that is what is animal law. And when we say animal law, we are referring to an area of law. And an area of law, any area, civil law, criminal law, human rights, etc., or constitutional law, is an area of law is defined to a special area that has their own legislation, that has their own jurisprudence, their own sentences, their own doctrine, books, scholarship, etc., dedicated to that area. And in the case of animal law, we have a lot of judgments here in the United States, or also in many countries that already are regulating the situation of animals. And also we know that we have legislation regulated the welfare of animals or the protection of animals. Here in the United States, we have the Animal Welfare Law, the Animal Welfare Act, and also you have the Endangered Species Act, etc. And in the case, for instance, in my home country, Peru, we have also Animal Protection Act. Animal Protection Acts around the globe differ in their characteristics, because some of them are more protective than others. Some of them consider only to companion animals. Others consider only to vertebrate animals. Others protect only native species and not introduced species, etc. But that is what is beautiful, because when you are a lawyer, you try to take advantage of all the legislation available, and also you have to fight against that lacunes or legislation that are putting in danger the protection of animals. And that is basically, that is.
Cool. Thanks so much, Marcia. Recently, the students in the class, so before we get into a discussion focused on your pieces that they're reading, I just wanted to mention that they recently have read, for example, sections of Animal Liberation by Peter Singer. They've read a piece on the property standing of animals that Gary Francione wrote, and they've also read a chapter from Zoopolis by Kimlicka and Donaldson. I'm sure these are all pieces that you're aware of. While their philosophy, they have a bearing on the sort of legal status of animals, right? And so the distinction that we've been going through, at least the last week and a half or so, is well, at least one major point that we've been engaging with is this distinction between welfare perspectives, which tend to be framed around, like utilitarianism or consequentialism. So certainly Peter Singer is perhaps the most well-known figure who advocates for this kind of approach. And then, somebody like Gary Francione or Kimlicka and Donaldson, right, are putting forward rights-based approaches that put forward a claim for inviolable rights for other animals. And these are radically different approaches, right? Gary Francione gives a good overview of the legacy of the last 200 years of animal protection, right? And how that's been framed around the sort of welfare-based approach within which animals have always been, property, right? And that's always been a hindrance, right, to like actually achieving real animal rights, and so I just was wondering if you could comment briefly on that, because I'm sure this is something that in your field, I know that this is a constant battle, right, between like people that withhold or that take a sort of like welfare-based approach and people that take a rights-based approach. And certainly the majority of organizations in terms of animal protection, animal welfare organizations are framed toward a welfare-based approach. So I just wonder if you could comment briefly on that.
Yes, of course. Okay, we know that in the animal theory in general, we have welfarism and animal rights as a dualism. Usually they are discussing and debating between us, and they are contrary between us. I think that you have taught this to your students, but we know that welfarism regulates the use of animals, so we can control and we can reduce the amount of suffering that they will suffer. And on the other hand, we have animal rights, that the main point is the total liberation of animals and rights for animals. But the problem in law, this dualism is what can I say, is pragmatical, but only as a theory right now. Only when you study ethics, only when you study political theory, etc. But from the point of view of the law, that we as lawyers, we work with legislation that the Congress will write, or regulations from the agencies, for instance, from the Department of Agriculture of the United States, of the Ministry of Agriculture in other countries. We have to work with legislation and also with constitutions, etc. But we don't have so much liberty or freedom to say as lawyers, hey, all the animals have to be liberated, and we have to take an abolitionist position. What we have to accept is, as lawyers, is that currently all the systems that protect animals around the globe are welfarist. That is, the Animal Welfare Act in the United States, the Animal Protection Act in Peru, or other animal protection acts around the globe are welfarist. So they are regulating that animals don't have to be subject to unnecessary suffering. Exactly, I can say that the most of the legislation around the globe say that as a principle. Animals don't have to suffer in an unnecessary way. Nevertheless, when we have this aspiration to achieve real rights for animals, it is not impossible, because we can take this legislation or these constitutions that are already welfarist and progressively to change this point of view, this approach towards the full realization of animal rights. For instance, you will read in one of the lectures the case of Estrellita, that I think that after we will discuss a little about that. But for instance, currently Chile is working a new constitution. They will go to elections for approve the new constitution, whose articles are already right now. So this constitution will have like 4 provisions to protect animals. And one of that provisions say that animals have the right to not suffer in an unnecessary way. So of course that they are maintaining this welfare language of unnecessary suffering, but you also, at the same time, you are talking about rights. So this is a very powerful, because at the same time, the other of the provisions of this new constitution that will be enacted in September 2022 say that animals are subjects or special protection. So we are not talking anymore only as animals as objects and from a welfarist perspective, but also, yeah, we are migrating with so much effort from activists and lawyers. We are migrating from welfarism to plenty of full animal rights. This is a very hard work, because of course that everybody can take the individual decision to take a vegan life, or to take to have a life where you will not enslave animals anymore. But as a society, as a political structure, as a state, and in the legislation itself, to change the status quo is very, very difficult, because you will have many powers fighting at the same time. And when I say powers, is that you have animal rights activists here, and you have the lobby of the meat industry and milk industry, etc., here, and they will be fighting. And the battlefield is, the most of the time, the Congress. The congressmen, at the end of the day, are the people who do the legislation. So yeah, that is very difficult. But we see that from the welfarism, we are migrating to real rights for animals. That is seeing that is how the law works.
Thanks so much. Yeah, that's really fascinating, and sounds like a super complicated field to navigate. And I know certainly, like, I'm curious to hear the perspectives of some of the students, right? Because certainly Gary Francione, right, will say something like that. Really, that those sort of like welfare kind of advancements, right, could actually, oddly enough, he almost takes a utilitarian perspective in terms of like the long-term implications of this, right, like could just allow things to continue on, right? you know, like if we don't ultimately question the property standing of animals. Now, of course, right, there's many different ways to interpret that, and I'm not like pushing back against what you just said, but I think that that's just, I'm just curious. I want people to work through this and come to their own conclusions, but certainly needing to navigate existing laws, existing kind of views of animals, while also attempting to enact more progressive legal standing for them is seems like a very complicated field to navigate. Yeah, I guess like we can get into the meat, I guess, of this discussion and go right into talking about your pieces. Does that sound good? There are two different readings that you have for this week by Marcia, and that is Multispecies Families in Latin America and an analysis of the Estrellita constitutional case from an animal rights perspective. So I thought we could, you already talked a little bit about points that intersect with both of these pieces, you know, using existing laws and trying to incorporate animals into the legal structure, right? And so I think the multi-species families in Latin America piece is maybe a good place to start. Would you mind just giving us some of your brief thoughts on this and kind of like what you feel like the key takeaways or key points are from this piece?
Yes, of course. As I was saying, in law, we work with legislation, but also we work with courts, because you have a law, but also you can challenge a certain law in front of a court. So I could say that the bigger changes in relation to human rights and protection of the environment and also protection of the animals are occurring not in the legislation, rather in the jurisprudence, in sentences, in the work of courts. So what happened is this paper, Animal and Multispecies Family in Latin America, I am referring to Latin America because it's my own legal system. So I know how it works, but I know that currently many judges and courts around the globe are recognizing the existence of a concept known as the multispecies family. And even they don't need to mention the word multi-species family, but they are recognizing that animals, the companion animals, are maintaining a special relation with their humans, so they have a special protection. And when you read the judgments, they are referring that animals are playing an important role for this family. So progressively, we will see that even the same judges say that this animal is the member of this family. So this is a concept of multi-species family. Multi-species family is a concept that has been worked more in sociology and in psychology. And this is so beautiful because you can take the studies of other fields to the law, and you have to combine a judge or a set of judges that this family consider this animal as a real family member. So in front of when for instance there is a divorce between two persons, you cannot simply say, okay, the wash machine will be with you, and this table with you, and the dog with you, and the door with you. No, you have to take into account that the animal is a living being, but also is a sentient being. And yeah, the courts progressively are recognizing that companion animals are first sentient beings. They cannot be treated as objects, but also they are recognizing that companion animals are not like farm animals that have a commercial value, rather that companion animals are linked with their humans, not by a commercial link, rather by an affective link. And that humans consider the animal as a real family member. So as you will see in the reading, there are many, and this paper is from 2021, from the December 2021, but in 2022, we have a new judgments about multispecies family. So what mainly the multispecies family said is that humans now more than ever are considering their companion animals as real family members, because there is no anymore that relationship where you have a dog in the door of your house, or the dog is sleeping inside of your house, but there is not a real connection. Rather that we have this phenomenon where currently the people is taking these animals as brothers, as sons, as children that they have to care. And they are not only opening the door of their house to these animals, rather they are expending money, time, energy for them in a similar or in an equal way with another family member, human family member. So we have this reality. As you love your companion animals, you also will suffer when these companion animals will be damaged by the state or by a private person. So if you consider a being, a sentient being, because now the most of the legislation also consider animals as sentient beings. So if you are considering this sentient being as family member, well, you have the right to that a judge or an official, a state official, consider your animal as family member. So you have to protect this sphere of intimacy, of privacy, of family privacy. So you will not only protect the mother or the son, but also you can begin to protect the dog too, because this dog is fulfilling a certain role. In this case is, for instance, a dog can give protection, care, love, emotional support, etc. So if you take off the dog from this system, from this family system, you will damage the whole family, and that includes human beings that are protected by human rights or by constitutional rights. So I don't know if that was understandable, but we are taking this concept from psychology and sociology that have studied, these two fields have been studying this system, family system that is including animals, and we are taking this concept in front of judges.
Thanks, that's super cool. And I think that like a really interesting part of what you're talking about, right, what you said right now, and certainly in the piece as well, is that this isn't necessarily questioning, like, it's not really questioning existing laws. It's just like, because these roles in a sense already exist, right? These roles already exist, but usually people, at least usually in the history of the way the law has been applied, it has applied to humans, right? But the case is pretty clear, right, that a number of humans see other animals as family members in perhaps a very similar way to the way that they see other humans, right? And so in that sense, it's not really like it's not really like questioning the law as much as just questioning like that, you know, maybe like the way in which the language is being used is being questioned. Is that a valid point perhaps, or what are your thoughts on that?
First of all, we have to know that currently the legal concept of family is considering only to the mother, father, son, mainly that, because the judge will see what are the consanguineous link, the biological link. But this is changing, because now we know that we don't have anymore only this traditional family where you have a mother, a father, and the son or the child. Now we have two mothers and one child, or we have two fathers and two childs, and also we have a grandmother with the with the child because the mother dies and the grandmother is taking the place of the mother, etc. So we can now put these new structures of family that indeed always have existed, but now, thank you to the human rights, we have a broad recognition of these new structures of families. So considering that this concept, this traditional concept and legal concept of family is changing, we can also say that, hey, you have to also consider that there are certain families that consider their companion animals also as family members. And this is an evident fact. And we in law, we know the lawyers know that facts that are very evident, that are, for instance, a big new that everybody know about, or an evident fact like, for instance, a mother that suffered for their son, that kind of feelings that are common to everybody, we know that these evident facts don't need to be proved. No, so the judge, you don't have to go to the judge and show a psychology analysis or a psychological exam saying this person considered their dog as family member, because now we know that it's evident that the people who have dogs in their houses really love these dogs. So this is not new, but what is new is the new approach from the law, because until now, family law and the civil law have been very traditional. They have been protecting the traditional family, the sacred family that are on the marriage, etc. But now in another time, when we know that we have to respect the autonomy of people, how they decide to have their family, because from my autonomy, I can decide to have a husband, but also from my autonomy, I can decide to have another woman as partner to begin to create a family with this woman. So if you respect the autonomy, that is a human right and is a constitutional right, if you respect autonomy, you will respect the new kinds of family. And as you will see, the paper talks about this. We are using the right to free development, to the free development of the personality. And this right is one aspect of the right to autonomy.
Thank you. Yeah, and I think it's also a really good connection to so the chapter on the students in this class are reading from Zoopoulos by Donaldson and Pimlica. I think that it's a good connection because right, they make the claim that denying rights for animals based on the factors that are usually like the rationale that's usually put forward, like, for example, something like cognitive complexity and so forth, right, is endangering human rights, right? It's endangering human rights because like it's using a rationale which is going to deny rights standing to a lot of humans, and actually really all humans at some point in their life, right? Because if you're using sort of like complex cognitive capacities that somebody like, for example, Singer might claim, or some even, you know, some rights-based approaches are based in like this kind of complex cognitive claim. If you're using that kind of approach, you're going to deny that infants have inviolable rights, and you're going to deny that, for example, someone who's elderly and senile perhaps has inviolable rights. And so this is also, right, it's an interesting connection, because it's saying like this is endangering the standing of families that don't fit into this sort of like whatever traditional Western conception of a family, right? If you deny that animals can be members of a family, right? I think that's kind of a fascinating connection here that you're drawing. So thanks so much. I think it's a super cool piece, and I really hope that you all watching also really enjoyed reading this piece. So to conclude, right, I was just hoping that we could talk a little bit about the Estrellita case. So the other piece that you're reading for this week is called, by Marcia, is called An Analysis of the Estrellita Constitutional Case from an Animal Rights Perspective. And this is a very recent case that has been in the news quite a bit, actually. And so it's very relevant, and perhaps you've heard of it already. And if you're interested in the concept of rights of nature, right, this also really is relevant. So yeah, so if you could give us, Marcia, if you'd be willing to just talk a little bit about what you think the primary points from this are and your experience engaging with this fascinating case.
Yes, of course. I think that there is a lot of connection with the first paper, Multispecies family, because Estrellita was a monkey that was part of a multispecies family. The story is like this. We have in Ecuador, Estrellita monkey who has lived for 18 years with a person, with two women in Ecuador. So one of them is a plaintiff in the case. Estrellita was living with, the name of the plaintiff is Ana. Estrellita was living with Ana since she was 1 month old for 18 years. And between the family, there were a strong connection of love, of support, etc. Indeed, and this is not so much good from the point of view of the animal as a species, but Estrellita was treated as a son, as a child, no, as a daughter of Ana. We can say that Estrellita was happy in this house because she was giving with a lot of love, etc. But of course, was not the optimal, the better word for the better place for a wild animal, because she was a woolly monkey, and woolly monkeys lives in the forest of Ecuador. But the case of Estrellita is very particular because was living a lot of time with this person, and she was unable to be reintroduced to the forest, or it would be worse to take Estrellita to the zoo. But that was what happened, because in 2020, after an anonymous complaint, the authorities of the Ministry of the Environment of Ecuador went to the house of Ana and take off Estrellita. They confiscated Estrellita using force. And this was a big trauma both for Estrellita and the family. We know that Estrellita died 1 month after she was transferred to the zoo, but the family was unable to see Estrellita for months, and they discovered that Estrellita was died like in, we can say, 4 months after the death of Estrellita. So this case initially, and I know that you are reading about the website of Non-Human Rights Project, you will see that the Non-Human Rights Project is dedicated to suit habeas corpus for animals. And habeas corpus is a special judicial process to ask for the liberation of a person who was illegally imprisoned. So, for instance, if a policeman take you to the prison without any explanation and without giving notice about a crime that you committed, or in an arbitrary way, you or any other person can go to the judge and say, I want an habeas corpus for liberate this person that has been arbitrarily detained. And that is what lawyers are trying to do in the world, and the Human Rights Project is trying to do in the United States for animals, because in this case, animals are imprisoned in zoos. So that was what happened in Ecuador for Estrellita. A group of lawyers presented an habeas corpus for Estrellita, and as they discovered that Estrellita was died, they say, okay, Estrellita cannot be liberated anymore, but at least we have to have the body, because we love Estrellita and we at least wants to have the body to give a ceremony for the body. I don't know. The family also was very affected emotionally, so for they it will be very important to give a ceremony, or at least to see that Estrellita is really deaf, to be more quiet, no? So this is the life of Estrellita, how the facts of the case occur. But what was amazing is that this case that was so painful for the family and Estrellita was selected by the Constitutional Court of Ecuador, that is the most important institution in a country that has a constitutional court. You don't have in United States a constitutional court, but it's very, very similar to the Supreme Court. Maybe with a little more of power than the Supreme Court. So this case was selected for the Constitutional Court of Ecuador, and in this case, using this case, they developed absolutely beautiful judgment when they recognize that animals, and here I have to do a parenthesis because Ecuador has since 2008 the recognition of the nature as subject of law, as legal person. That means that nature, as any other human being, has rights. The problem is that define what is nature, and usually the people would say that the Constitutional Court began to say that nature is only physical places, rivers, mountains, etc. But progressively they have been saying that animals are also part of nature, and animals have rights, but only as a species. For instance, to say this group of condors, the species of the woolly monkey have rights, so they have to be preserved, but not for individual animals. And this was the first time that in the case of Estrellita was the first time where the court said individual animals are part of nature and are subjects of law and have rights. So animals are legal subjects and rights holders. And also the court has established a set of rights for animals. And also the court has established that, okay, the animals have right to life, the right to body integrity, the right to not be hunted, etc. But we have to recognize that humans continue using animals, so you have to evaluate all these rights from the ecological principle interpretation, principle of ecological interpretation. So from the principle of ecological interpretation, we know that animals are and there is an interaction between animals, and in these interactions, sadly, humans use animals, so even when they have rights, they can be used yet. So this is confusing because you have rights, but at the same time, human beings can kill to you for meat, for even for leisure, because the court say that the human beings use animals for leisure, for work, etc. So there is an inconsistency in this case, but even though this case is absolutely amazing because it's the first time that a constitutional court, that as I say again, is the most important institution in a country, in this case in Ecuador, that has recognized animals as legal subjects. So this is amazing. And thanks to this case, the court has given the mandate to the Congress of Ecuador to enact a new animal protection legislation that will establish the rights of animals. So again, we are talking about real rights. So I will be I am very curious about how they will talk about rights, but inside of a society that continue using animals. It will be very amazing. I think that we will have a lot of work and material to study in this case. But yes, that is the case of Estrellita.
Well, thanks so much. Yeah, so again, it's a super fascinating case. And I think you do a great job in in this paper of both critiquing it, critiquing some of the kind of like the conclusions of, like, you know, as you say, right, the way in which the principle of ecological interpretation is applied takes on a sort of welfarist approach. But then also, you know, as you mentioned in our discussion previously, like this is a way of perhaps advancing the interests of animals, albeit not perfectly, but towards perhaps towards a future of inviolable rights. I think that that's one of your claims. Yeah, so I guess I'd just be curious if you could talk just a little bit more about that connection, since we talked earlier about the distinction between welfare and rights. If you could maybe highlight how you see a connection between the way in which the principle of ecological interpretation is being applied and the sort of welfarism that somebody like Gary Francione is critiquing, right?
Mm-hmm. Yes. Well, the point of view of Gary Francione, from my point of view, is a little impractical. It's not pragmatical, because we cannot avoid never to have contact with animals. We will have contact with animals, even if we don't have companion animals anymore. We will have rats, pigeons, birds, and many animals around us. So we have to regulate our relationships with them, and that is the law. The law is a normative system. We have religious system of norms where God say to you, don't do this. And we have also moral systems of norms when you know that this is incorrect, that this is correct. Law is also a normative system, but in difference to the others, to the previously mentioned, the law has something that the others don't have. That is the coercive force of the state. So if you don't obey the law, you will take into the prison, or you will be obligated, you will be a subject of a fee. So at the end of the day, I think that the law is the better instrument to protect animals, because it's okay to say morally it's incorrect to damage animals. It's correct that for me it's good that a relation or a determinate religion prohibit the consume of animals, etc. But the law is important because the law is the only normative system that has the coercive effect. So it's important to regulate our relationships with animals. I'm sorry, and this will I have to charge this computer. Give me a moment, please.
Oh yeah, no worries.
It's okay.
Technical difficulties.
It's done.
Okay, awesome.
It's done.
So
I was saying that the law is the most powerful instrument for regulate all relationship with animals. So I think that is important. Now, to change the law and to change how judges think is very difficult, because as I said previously, we live in a world that wants to continue using animals. So we have to be very strategic. We can, as a lawyer and as a serious lawyer, I cannot go to the legislator or to the judge to say, hey, you have to liberate animals. We have to be vegan. We have to protect animals. No, because that is not a strategic message. It would be more strategic for me to say we have to protect companion animals because it's socially acceptable that you don't have to damage any companion animal. Okay, next step, we have to protect all endangered species. Next step, we have to protect all wild animals because you are not acquiring any economic benefit. The real challenge we will say, please, we have to protect for real to farm animals, to animals in laboratories, because they are generating a lot of money, so it will be more difficult to combine. So I am taking, sadly, because I consider myself abolitionist, and even I consider that we can live with animals in the future in a very peaceful way, but I have to take necessarily an welfarist position because I live in a welfarist world with a welfarist legal system.
Thank you. I think that was a really great answer. I was going to also ask you so obviously you are writing from the perspective of coming from Peru, right? And you're writing from the perspective of animals and the law in a Latin American context. And my experience as an animal ethicist, somebody working in this area from the global north or the west, right, is that oftentimes when you have discussions around these topics, people who push back against you frame it as a Western perspective or a global North perspective, right? And so something I find really fascinating about your work is that you are highlighting, for example, how indigenous perspectives in Ecuador are being used to further the interests of animals, perhaps, right? Or, for example, multi-species families in Latin America. This concept of the multi-species family is not something that, in terms of my experience, it's not something that you read about in English language literature. It's predominantly something that's written in Spanish language from the context of Latin America. And so I was just wondering if you could talk a little bit about what your thoughts are on that in terms of kind of the influence of a Latin American perspective on animals, because I feel like it's a very progressive perspective that is not getting enough attention in the academy.
Yeah, well, we have different legal systems around the globe, but the main legal systems are the common law, that is in Anglo speaker countries like Canada and United States, and we have the civil law that includes the countries of Europe, continental Europe, Germany, Italy, etc. No United Kingdom, only the continental countries and the whole Latin America. And also we have Islam in the Islam legal system and Chinese legal system. But indeed they share some particularities, or but I consider that also they are very different between them. What is particular to the civil law that is Europe and Latin America is that we put focus more in the legislation, but after the Second World War and the enactment of the Universal Declaration of Human Rights, etc., we progressively have been migrating to give more power to judges to decide in a case-by-case basis in order to protect human rights. So even when the legislation said, for instance, my typical example is the legislation say that a person who is considered the father of a baby has only 6 months to challenge that to go to court with a proof of DNN saying this is not my child, no? But if you don't do that in 6 months, you legally are obligated to be the legal father of that baby. That is what the law said. But we know that from a constitutional point of view and a human rights point of view, all the human beings have the right to identity. So with this right to identity, you can go to court and say, hey, I know that the 6 months has passed and we don't have any 6 months anymore, but this child has the right to identity. So this child has the right to know that I am not the father. So we are challenging a lot the legislation, and this is different. The situation is very different here in the United States because you have a lot of deference to judge to the jurisprudence and also to the legislation, and it's very difficult. I have found a lot of difficulty challenging what the legislators said and what the Supreme Court said in relation to protect, in order to protect individual rights. But also in Latin America, we have a phenomenon that all the constitutions are very new, because, for instance, the Constitution of Peru is from 1993. The constitution, now Chile will have a new constitution. The constitutions are for 1980s, 1990s, or 2000s, etc., because they change a lot, no? So the most of the constitutions in Latin America are like it's not like a copy and paste of the Universal Declarations of Human Rights, but have, from my point of view, the most of the rights of the Universal Declaration of Human Rights. So we have the right to life, the right to live, freedom, the right to, etc. So it's easier to use to interpret these rights in favor of the people, but also I consider that this big set of rights that we have in the constitutions are very easy to interpret in favor of animals. Because, for instance, the most of the constitutions in Latin America have the right to a healthy environment. So you have the right to live in a healthy, in a peaceful environment. And this right progressively has recognized that includes the animal protection, because of course, if you are living in a house where the neighbor is killing animals or is committing cruelty against animals, you are not having a healthy environment. So this right has been so beautiful and so powerful to protect forests, to protect animals in cities, to protect many things. No, even you don't need to consider the environment as the environment surrounding you. You can challenge you can challenge a situation that is in the other side of the country, because the information about the cruelty of animals in the other side of the country is arriving to you, I don't know, by television, by news, by the social media, and you are feeling really bad, and they are affecting your environment, your tranquility, etc. So that is an example of how we are using this big set of rights that we have in the Constitution. That is a little more difficult in a constitution like the United States, because you have a set of rights, the Bill of Rights, that are rights from the 1790, or the first years of 1800s, I think. I'm not so sure which is the year of the Bill of Rights, but this Bill of Rights never knew about the Universal Declaration of Human Rights in 1948, for instance. So that is a particularity of Latin America, and yeah, we are using those human rights.
Yeah, thanks so much. And also it reminds me too of like some of what you're saying about how more progressive possibilities can happen in like younger constitutions. That I think it's interesting to think about in the context of the US as well, because so recently, like last week in this class, the students watched the movie on Joanna MacArthur, The Ghost in Our Machine, and she's an investigative photographer who does a lot of photography of animals in, for example, like fur farms and industrial agriculture and so forth. And having met her a few times and talked to her, I know that she says that she really doesn't do a significant amount of photography in the US because of the way in which the laws exist in this country. It's just exceptionally difficult to get in and take photographs, and in many cases it's like you're risking serious jail time taking photos of what's happening in these sort of facilities, and so she is not able to take that risk. So she does the majority of her work in an international context. So just reminded me a little bit of that. But I was going to ask you if there's anything else that you wanted to add in terms of perhaps just like your experiences in the field of animal law or in relationship to either of these cases, just to sort of conclude our discussion for today. And I also wanted to add that that I'll be sharing Marcia's email address. So if any of you are interested in reaching out to her about the discussions that we're having today, or you know, after you read the papers, her papers for this week, if you have a question for her, I know that she would love to hear from you. So please feel free to reach out to her. So I'll just let you have some parting words right now.
Yes, of course. I would really appreciate if you can write a message to me, an email. I am very happy because I think that what is more important is new perspectives. I have already perspectives from my experience, but I would like to know what are the perspectives of people who is studying animal and environmental ethics, no? So it will be, I think it will be very rich for me too. And in relation with your question, what I can add from the animal law perspective is like it's very broad. It's a new field. I am very excited because animal law is not only one area when you have to study. It's not only one path. It's a horizontal path when you will study animal law in relation to criminal law, in relation to constitutional rights, in the relation to human rights, etc. So animal law impregnates many fields, particularly for instance, I like so much study animal law in relation to international law, what international treaties exist for protect animals, or to draft new treaties for protecting animals in a global scale, or also you can study animals in the law of war, how you will protect animals in war conflicts, etc. Or you can study animals in the constitution and how you can redact and how you can be part of new constitutions in the future, or how to interpret the constitution for protect animals, etc. So it's a big area when you have to have a lot of creativity, and what is more important for me is that allows to you to work with law, but also in intersection with biology, with ethics, for instance, what we are doing here now, with political theory, etc. So even if you are not deciding to study law in the future, you always will be necessary for the law. So you can dedicate your career to protect animals in different ways, and your work could be used in one moment for the Congress to enact new legislation, or for animal lawyers to use your arguments to protect animals, etc. So that.
Well, thanks so much. Yeah, certainly, as we've already learned in this class, environmental ethics engages with a lot of different disciplines, right? I mean, like it's necessary to engage with science, with, you know, certainly with sociology, psychology, political theory, and so forth. And as you said, right, animal law, that's something that's so fascinating to me about it, is that it's on a first glance, when you hear about a field like animal law, you're thinking this is all just going to be a bunch of lawyers. But in fact, in many cases, the conferences and the people engaging in the conversations, majority of them are oftentimes not lawyers. A lot of them are philosophers, and, you know, and political theorists and so forth. As you said, there's people coming from a whole variety of different disciplines, and all of those perspectives are crucial in this field. And so I encourage you, like, to if you found this week really interesting, the readings and this discussion interesting, I encourage you to do some more research. And, you know, if you are in the field of, I know that perhaps some of you are interested in going into law, environmental law and animal law are really emergent, growing fields that are important fields. But even if you're not in law, right, there are your perspectives are probably going to be crucial. So just keep that in mind. And I am looking forward to engaging with you in the discussion boards this week. And I'm looking forward to reading your reading responses as well. And I want to thank Marcia again for joining us. I know that you're extremely busy and you have you know, like you're engaged in academia and you're still working as a lawyer, which I think is such an amazing thing to be able to navigate both of those worlds simultaneously. So thank you for making the time to join us today and to share your fascinating work and your perspectives with the students.
Thank you, Bjorn. Thank you.